It says I'm now unmuted. Am I unmuted? Hi, everyone. So it's 2:45. We're going to start the next section of the policy update, CLE. I'm just going to take this off the mic stand. It'll be a little easier. So my name is Juliet Summers. I am the policy coordinator for child welfare and juvenile justice at Voices for Children in Nebraska. I am here today with Sarah Helvey with Nebraska Appleseed, and we are going to go give you a quick blast through some other policy updates that happened in the most recent legislative session. It's a hard act to follow going after Robbie because he has such in-depth and really detailed, excellent knowledge of everything that's happened with ICWA. Our presentation will probably be a little bit shorter. We don't anticipate taking the full hour unless there are really in-depth questions that people have. So please, I think I speak both for me and for Sarah, if you have a question as we go, just shout it out, interrupt us. We won't bother saving time for the end because we'll have plenty of time at the end. So as I said, my name is Juliet Summers. I work for Voices for Children in Nebraska, which is a nonprofit, nonpartisan policy advocacy organization. That's mumbo jumbo. Basically what it means is we do research, analysis, and advocacy and public education around issues that affect children's well-being in the state. As the policy coordinator for child welfare and juvenile justice, all of my work is centered around basically kids in the courts or kids at risk of becoming involved in the court system. And a little bit, kids who have been involved in the court system. So what we do, this is our mission statement: informed research drives our direction. When a policy is good, we support it. When it's harmful, we fight it. When it's missing, we create it. And community engagement is how we promote systems change. You may have already heard of Voices for Children because of our sort of flagship document. We are the Kids Count affiliate in Nebraska. This is through the Annie Casey Foundation. Every state has a Kids Count organization to compile data on all measures of child well-being in the state. Every year, we have one research coordinator who's dedicated to doing this. She works with all the various data systems across Nebraska to collect and compound pretty much any statistic or piece of data you'd like to know about how kids are doing in the issue areas we work in. So health, safety, which is child welfare and juvenile justice, economic stability, and education. And I brought a few copies. I don't know if I have enough copies for everyone here today. I didn't know if everyone would want one, but I have some here. And if they're all gone and you don't get one, you can log on to our website, voicesforchildren.com, and we'll mail you one. Or you can reach out to me and I'll make sure you get one. And I also, while I was here, I brought a couple of our deeper dive issue briefs that we do on particular questions. So once we have this whole huge data set, Kids Count looking at everything, sometimes we like to pursue a particular area and see what's really going on. Let's dig in here. So I brought a couple related to my part of the presentation, juvenile justice, that are recent. A data snapshot we did on status offenders in the state, looking at how policy changes in the last few years have affected the numbers of status offenders coming into the system and how they're handled once they're in the system. And then the YRTCs, what's going on with the YRTCs. Okay, so that's kind of the research, the data part. We always try to work from the data to then move into, okay, well, what does the data show? What does research about best practices show? What can we do in Nebraska to try to move our state along the path to reform to get better outcomes for kids? That's the second piece. And then finally, community engagement is how we promote systems change. It's not enough to just have this information, this research. And it's not enough even just to tell legislators, here's what we wonky policy organization thinks is best. It really has to come from the ground up, from what's going on in homes across the state, in courtrooms across the state. So I'm going to talk about a couple policy changes in juvenile justice, and then I'm going to give it over to Sarah, who will talk to you about a couple things in the child welfare realm. So the first one I'm going to focus on, and you have a document in your materials that's intended for defense attorneys or attorneys representing the child in status offense proceedings, or in the case of shackling, in any delinquency or status offense proceeding. So just be aware that you have that. What LB 42 is there's two prongs to it. So one half of the bill was about status offenders specifically, and the way we are going to try to screen away status offenders from the court system where possible. And then the other part of the bill addresses the use of restraints or shackles in the juvenile court, and that applies not just to status offenders, but to all youth coming before the juvenile courts. So I'll talk about both pieces. The sort of reasoning or philosophy behind this piece of legislation generally is both nationally and in Nebraska, we're kind of moving away from the idea that the court is necessarily the best place to respond to child, even criminal misbehavior, but certainly non-criminal misbehavior, that judges and attorneys, I know I'm speaking to a room of judges and attorneys, but we're not the magic sauce that's going to solve problems like running away, like being truant from school. And too often, again, nationally as well as in our own state, we have relied on the courts as an agent to match kids to the services that are the magic sauce. So we have often heard you have to get into a lot of trouble before you get any help. I think this is a common refrain. We hear that, you know, say, I think a good example is truancy. A kid who's being truant from school, they get into court, the judge orders them to participate in some kind of educational support program, and then they start doing well. If we can try to get them into that program, eliminating the step of coming to court, it's going to create the same positive result, but minimizing the harm to the child. Because the other thing that we're starting to understand is that the court process itself is harmful to young people, particularly this lowest risk population. One court appearance, a study coming out of Texas showed controlling for other factors, one court appearance made a young person 4 times more likely to drop out of school before graduating high school. So we know that, like I said, the court process itself can be harmful. Let's try to get services and assistance in place as much as possible without having to resort to that. So that was my long introduction to LB 482 and kind of I think the thought process behind it in the legislature. For the status offense population, the 3 Bs, it does a few things. It emphasizes pre-court and community-based efforts. And this is in conjunction with legislation that previously passed, dedicating funding to counties in order to try and grow some of these community-based resources. So if we have a kid who's coming in for a status offense and we also have available resources in the community, let's try and get them to those resources without having them come into court. So the first thing the statute does is it gives police the discretion to refer a family directly to providers rather than citing a child and pitching it over to the county attorney's office to do that. And then once a county attorney becomes aware of a case, a family, a child who would qualify as a 3B, they're required to refer them to community-based resources that might address the problem and de-escalate a crisis situation. Excuse me. Thank you. And those efforts have to be described in the petition. Failure to describe those efforts is a defense to adjudication. So once, and then a couple other little things on sort of the front end of cases. Someone who's charged or alleged to be a status offender, if they're arrested or brought to a police station for some reason, may not be fingerprinted. This is again in line with that kind of philosophy of trying to decriminalize kids who haven't committed a criminal act. And finally, there's a particular provision about staff-secure detention facilities. So the statute, and this isn't on the PowerPoint, I'm sorry, the statute emphasizes that status offenders can't be placed in detention facilities. We already knew that was the law, even on valid court orders, exceptions. They now no longer can be placed at staff-secure wings of those facilities unless the wing and the facility fully comply with both the federal and the state statute requirements of what that looks like. It's got to be something, it's got to be a different animal than a detention facility. So, I'm sorry, I got a frog in my throat. So what does that really mean? It means that supervision and what's keeping the child in that placement has to be staff supervision. It can't be physical construction. If you are an attorney for a child who their only charge is a 3B charge, and the court or the state is looking at detaining them in a staff secure detention facility, you need to be asking questions about what does that facility look like? What are the modes of ingress and egress to that facility? Is it a buzzer locked door that a staff member in the room opens up? Is it a double buzzer locked door where they're stuck in like a waiting chamber in between? If you're a child in that facility, are you, like what's the deprivation of liberty look like there? So that's a fairly substantial change, at least in a couple jurisdictions. There may be some questions arising out of that. Oh yeah.
I don't know if you know the specifics, but so the detention staff, the staff support portion in Lancaster County is going to disappear, or is that going to relocate somewhere else, or are they going to make changes? I'm not sure how we can do that. This is like going to jail, basically.
Yeah, I can't answer. So the question is, how will this affect the Lancaster County Staff Secure Detention Facility? Is it going to disappear? Will they make changes? I also don't know the specifics of that. What I do know is Lancaster requested an opinion from their county attorney as to whether the staff secure wing of their detention facility complied with the requirements of the statute. And I think if anyone wants to take a look at it, I think the statute is 43251.01. Yes, 43251.016. So you can take a look when you get home and see, based on your experience, if you visited a client in one of those detention centers, whether this might be a fight you want to take on. My belief, I have not personally been at the Lancaster Staff Secure or Secure Detention Facility, so I can't speak to that one. I think it's going to come down to really technical evidentiary questions of how the facility works, how the wing works. Can the child physically exit? Is the child restrained by some kind of locked door construction, or is it just through staff supervision? Because the language of the statute refers to staff secure detention facilities, that refers back to an older statute defining that a detention facility or staff secure detention facility is a county constructed building. So it's probably not going to apply to your staff secure shelters. Like there's a couple in Omaha, I know, like a Boys Town one. This is going to be specific to those counties, Sarpy, Douglas, Lancaster. I think there's one out in Madison that have created a specific quote-unquote staff secure wing of the otherwise secure detention facility. I don't know if that answered your question adequately.
Yes, I guess we don't. Do you know what the results of that opinion from the county attorney?
I don't know. I haven't heard that the county attorney has come back with the opinion yet. I haven't seen anything on it yet.
What we're finding in practice is that this is actually making children less safe. Running is one of the most dangerous things that a young person can do. You're 12, 13, or 14 years old. You run away from home. You might be gone for 3 weeks, 6 weeks. They're caught. If they can't be placed in a facility that can keep them safe, they'll just run again. It could be they're being sexually abused at home. We don't know why they run. We don't know what they've done when they've been on run. They could have been sexually abused on run. They could be in the process in sex trafficking. We have to be able to keep these kids safe. And I think that many times these laws that are passed have good basis and a sound basis. It doesn't sound good to lock kids up, but it's important to keep kids safe. And so we have to balance that.
So I think this was more of a comment that it's important to balance these reforms on decriminalizing kids with, of course, the court's, necessary task of keeping kids safe. Is that a fair characterization? And I guess my response would be Nebraska is the only state that has created staff secure detention facilities. So other states And it was sort of in response in some ways to federal legislation that came down that said you can't securely detain status offenders. So this is a population of kids who, as you say, it does include runaways. They haven't committed a crime, but for whatever reason, we don't know where they are. We don't know why they're running. We don't know where they're going. And so I think our instinct is, what can we do? What can we do to keep them safe? I think what this law's intention is, without trying to read the minds of legislators, is to say that is still the most important consideration, but detention facilities aren't the right place to do it, so we need to create something else to fill that gap. We're not going to fill the gap of keeping kids safe by treating them like criminals when they haven't engaged in criminal behavior, especially because, as you say, some of these runners are running from something. So they've already been victimized. They already have a history of trauma.
They were likely victimized while on run.
And they may well have been victimized on run as well. So we're not going to take the added step of traumatizing them through the way we respond to this misbehavior. And that's not to say that we have a perfect solution yet. I think depending on how things shake out with this and what the findings are about staff secure wings of detention facilities, there may need to be further state investment in alternatives that are truly alternatives to detention. But I think the problem is we have this workaround right now where we're saying we're not securely detaining this population that federally we're not allowed to detain. But is a staff secure wing really a different animal, or is it walking, talking, looking a lot like a secure facility? And that's what this legislation is trying to get at. So I don't have the answer practically, functionally on the ground of how each facility is going to be evaluated by judges to make that determination of whether status offenders can continue to be placed there. But sort of the purpose is it needs to be something different. These kids aren't criminals, so we want to hold them safe, but we need to do it in a way that's not going to treat them like criminals. Along kind of a similar line, the next part of LB 482 and the way it relates to status offenders is it requires higher level findings before 3B kids can be placed out of the home as a dispositional order. So this isn't an emergency temporary custody situation. This is a dispositional order of the court after adjudication and after evidence has been received about disposition. There has to be a showing that available community-based resources and services have been exhausted that would assist the child and family to resolve the issues. And it has to be shown that a significant risk of harm persists to the child or community if the child were to remain at home. So I think as lawyers, we probably know that significant risk of harm opens the door to a lot of interpretations of what that harm would be. My suggestion is this is likely an attempt to stop the placement of kids in homes for continued technical violations of probation. So I think, depending on who your judge is, a judge may be able to say, well, I ordered the kid to go to school. He's still being a little bit truant from school. That's not following my court order, and if I send him to Boys Town, I know he's going to go to school. I think it's probably a fair characterization of how cases can go. I think under this language, that significant risk of harm to the child suggests that there needs to be a little bit something more there than the continued absences from school. Depending on who your judge is, the finding may well still be the same, but at least there's a showing that has to be made. Because ultimately, and again, I'll go back to ultimately, continued absences from school is a really bad thing. None of us want that for any of our kids in Nebraska. We want them to go to school. We want them to be successful in school. On the other hand, we have a growing realization that pulling kids away from their homes and communities is also a bad thing. And you should really do that as, just like a last possible alternative. If a kid who is coming before the court just for a truancy matter is continuing to be truant from school, we haven't gotten the right service in place to make that kid go to school and to get that education in the home. Is it really worth the damage that we may do to that child by taking him away from his home and community in order to achieve a result that we could maybe still get if we just tried something different? Finally, so those are the provisions regarding status offenders. I think I got them all. And then the other half of LB 482 addresses the previous practice of indiscriminate shackling of youth in the juvenile court. So when I say indiscriminate shackling, that means prior practice could be different in every courtroom, could be different in county to county, courthouse to courthouse. A child coming from a detention center, what was the courtroom or the courthouse policy about whether they would wear their handcuffs, their leg irons, while appearing in court before the juvenile court judge. You know, we know that the Supreme Court has held in adult criminal cases that you have a constitutional right to be presumed innocent and that the restraints you appear in can affect a judge's determinations on that matter. And also that you have a constitutional right to counsel and to be able to communicate with your counsel free from any interfering sorts of things. So it was sort of an odd anomaly that we have these protections for adults, but we don't have them for our kids, who we've already said you're going to a rehabilitative court. We're going to treat you in a rehabilitative way rather than a criminal way. What this segment of the law does, it doesn't say that you can never be restrained in a juvenile court, but it does say that the vast majority of kids who are coming to courts, even from our detention centers, aren't going to present a risk of harm to themselves or others or flight risk from the courtroom during their court proceedings. There may be the rare case where there's some reason to believe, you know what, this kid really does need to be restrained for his own safety, for the safety of those around him, or because we know he's going to take up out of his seat and run out of the courtroom. In those cases, the judge can make a probable cause finding that restraints are necessary to prevent the risk of harm to the child or others, or to prevent a risk of flight from the courtroom. There was some talk as the bill was getting passed about whether this would create an undue burden on courts, and realistically it's been implemented in a number of other states and jurisdictions, and they haven't seen a significant problem with court time being taken up on these determinations because they're really few and far between. And they also have not seen a decrease in public safety, because when implemented right, you're catching those kids who really might be a problem, and the vast majority of them, they're simply, during those court proceedings, not going to be a danger. So I think Miami-Dade County in Florida has had it implemented since 2006 with very similar language to what we have in Nebraska. They've had almost 30,000 kids come through their courtroom since then. They haven't had a run or a dangerous incident. Was there a question?
How do you deal with the argument from either the police officers or the court staff that they're walking in Madison, they're walking across the parking lot with police, and so in order to, there's like 4 of them together and 1 police officer, how do they then get them across the street and then into the courthouse, take everything off, go to court, put everything back on, and it's just a big waste of time? Because I've already heard that argument from police and from county attorneys and court staff that this is going to be a problem.
Well, I would say, I think, so the question is, how do you respond to police or court staff saying it's going to be a logistical nightmare, a huge problem of having kids, you know, having to take off all the stuff before they come into court and then put it all back on afterward. And there was, part of the question was about the kids walking through the parking lot. So I will say that the law only addresses in the courtroom. So, you know, counties can and courthouses can interpret it how they would like, and whether that will include transport or not, but the law doesn't specifically speak to the transportation process. It's because part of what the law is getting at is the constitutional implications. And that leads me to my next point, which is when you ask a child or a young person who has been wearing, you know, in court wearing handcuffs, wearing leg chains, what that feels like or what it means to them, their responses are really telling. In addition to feeling humiliated, feeling like a criminal, feeling like a slave, these are words that come from young people's interviews. They also can fixate. For instance, on the sound the handcuffs make, they're often very careful not to move because they don't want the jangling to interfere with anything. And simply wearing the chains during the court process can make them less likely to lean over and ask their attorney a question, or to speak up because they're feeling so embarrassed or they're so focused on not making the sounds. I think logistics should never trump constitutional concerns. We have all kinds, right? I mean, we have all kinds of protections in the law that may make it harder for courtroom staff or employees to do their jobs, but our primary principle in America is justice, is that we want to ensure we have a fair and dignified system of justice, even for those who are accused. So if we can do this, that should absolutely apply to our young people. And if we can do it safely, even if it means having to change our policies, then it's absolutely worth it.
I've got a county attorney's office you can talk to.
I'd be happy. I'll give you my card after. Although I should probably tell you all, my past life I was a public defender, so I don't know if they want to hear it from me. Were there any? And then the other thing I'd say on this is, the finding has to both be that the shackles are necessary to prevent substantial risk of harm or flight, and there are no less restrictive alternatives that would suffice. So if you're practicing in a courtroom that has sheriffs hanging around or escorting kids to and from court, you can make a pretty good argument that there's a sheriff in here who's much larger than my client, and so the additional imposition of handcuffs or leg chains probably aren't necessary to keep us all safe. Were there any other questions about LV 482 before I move on? That's probably the bulkiest one. Yes?
Well, this coming from county attorney.
There we go.
I'm not going to talk about the shackles because I don't have any problem with that one at all. But you put the onus on us to make referrals to people. Did anyone think to tell us how to do that, or who to refer to, or anything else? All of a sudden, we find out we're responsible.
So we have a county attorney in the room. We have a few county attorneys in the room who are pointing out the piece in the status offender portion of the legislation that requires county attorneys to refer to services, and like this is an imposition, and was there ever a question of are they able to do this? Do they even know who to refer to, et cetera? And I don't have an answer for you for that, honestly. Again, not 100% being able to read the mind of the legislature. What I can say is I think the hope is overall, as time goes on, this will reduce your caseloads. That if we can grow community-based resources in counties that county attorneys can become aware of, it probably takes a lot less time to simply say to the family, hey, call this number, than to file a case and prosecute a case and continue dealing with public defenders and the judge and probation and everybody else afterward. I know that's not a perfect answer for you today, but I would be I would be very desirous of your help on two fronts going forward on this. So the first would be to reach out. I'm just a policy advocate, so all I do is research and then approach the legislature and give evidence and talk about this stuff. But if there is a simple solution for how this could work that could be implemented in the legislative tweak for next year, that would be something I think that the legislature might be open to. The other thing would be if there some sort of compilation of available resources or communication between county attorneys and the Crime Commission on their community aid plans would be useful. That would be something we could try to hook up as well. I think I'm sensing that wasn't a happy answer, but that's what I've got for you.
Well, I'll be real frank with you. We're going to rely on diversion, and diversion also is a situation where they can say, no, we don't want to take part. It's got to be voluntary or it doesn't work. So if they do that, then I suppose we have enough to say we presented them with diversion. They denied it. We could file it if we wanted to. We could also not file it if we don't want to. And don't mistake me. I'm not out looking for status offenders because they are hard cases usually. But we've got therapists out there who are saying, call the police if this kid keeps doing this. I've got direct quotes from the therapist saying that.
Or they tell them, I'm a county attorney, Carolyn, and they tell them to call the county attorney as if we can just file a case. We have more situations where we have parents begging us to help them. That is more typically the situation. I see from a policy aspect, what you're saying sounds good, but in reality, in practice, it's really a little bit different. These parents who have these children who are, and they're at their wits' ends, they don't know what to do. They've tried calling the Boys Town hotline. They've tried going to therapists. They've done this, and they're just begging you for help. And we say, we're really sorry. We can't help you. Try this number. You know, we give out numbers, but you know, policy is one thing, but practice is yet another. And I think there's some unintended consequences of this law.
So I've had a couple comments that, you know, I don't know if I'm going to adequately recharacterize them, but there's a real concern with how it's actually going to work on the ground, and that from a county attorney perspective, what often happens is they'll get a family who's reached out to mental health provider, or they've had referred a kid to a diversion program, and diversion has denied them or it hasn't been successful. And then they're going to be faced with this choice of, you know, referring to another service or trying something else or filing, and that there's not adequate resources on the ground to really provide the answers in a clean, easy way that this law envisions. Is that fair?
And we don't really take parent walk-ins.
And they don't take parent walk-ins. Yes.
A week that goes by without a parent wanting.
That they're getting a lot of calls from parents, and that they're hearing a lot from you know, parent will call maybe over and over again saying, I've tried this, I've tried that. What, you know, file a case, I want you to take my kid. Is that fair?
That's fair.
And I have another hand.
I'm not a county attorney, but I get appointed to represent either juveniles who have been accused of such things, and also parents of juveniles in this situation. And I'll concur with that. And I have so many situations where parents are just after what they don't know what to do, and for the most part, really good kids. And then the services that are out there are, I mean, funding. We just heard a couple of ladies talk about how there's no funding for their tribes. And meanwhile, here in Omaha, I mean, we were talking about Boys Town and the Omaha Club for Boys. I think the other one you're talking about there. But I mean, they're full. I mean, you go on a waiting list, and in the meantime, you've got a parent that's going crazy because no matter what I do, I can't get my kid going to school, and I see my kid hanging out with the wrong people, and I'm scared to death that my kid is going to go down this path. What can I do? There's just not a whole lot else out there for them.
So a reiteration of this kind of general sense that parents are calling desperate for help, and what can we get them? We know that we have facilities, say in Omaha, that are full, that have waiting lists, and those are facilities that Omaha for Boys and Boys Town that you mentioned, you would in most cases need some kind of court involvement even to access, given those wait lists. So I think we have reality in Nebraska, which is, and here's my take, and you guys can all raise your hands and disagree with me if I'm not matching what you're seeing, which is an inadequate, no wrong door behavioral health system that's easy for families to access and easy for kids to get involved with, and is going to actually help resolve the problems. And so we have a system where families are calling county attorneys to please prosecute my child. That is a crazy situation if you step back and think about it, right? As a parent myself, it is very difficult for me to imagine how desperate a family must be to be reaching the place where they are blowing up a county attorney's phone saying, prosecute my child, take my child away and put them in a home.
Which is why people access the safe haven law. Remember that one? Yeah, that's why they accessed it, because they were so desperate for help.
So we have this reality, And then we have a perfect world, which LB 482 in some ways is envisioning or hoping or striving toward, which is where we have a flowering community of community-based resources that are actually going to help families respond to, child's mental health needs or problematic family dynamics. That is easy to access, and there's maybe one hotline you can call and you get into it and you're matched with what you need, and then the court doesn't need to be involved at all. That is some idyllic vision of the future, and we're not there yet. So I think perhaps what I'm hearing from some people in the room is a concern that LB 482 puts the cart before the horse and says, okay, here's how you're going to do things, even though we haven't yet built that behavioral health system, that beautiful network. And I guess my only response to that is we have to have a cart and a horse. We've got this one. So now what the legislature needs to do is continue putting its money where its mouth is in terms of funding community-based resources and making those funds easy for communities to get, for counties and county groups to access and grow these resources. And then we also need to have a real conversation about how we want families to be able to access those resources. And I think what LB 482 at least does is it says, we don't think courts are the right place if we can possibly avoid it. So we're going to make it harder on judges. Unfortunately, we're also going to make it harder on county attorneys, at least in this way of trying to refer, to have it come through the courts so that it may force change. It may force that next step for the legislature to take. And what I will also tell you in this regard is a bill that's on the books for next year is LB 499. It's just a shell bill right now. All the language says is that the Department of Health and Human Services shall create a statewide behavioral health system of care, and they shall work with the Office of Juvenile Probation and some other entities in figuring out how to create this. It's just a shell bill. It's probably too much to expect that there's going to be some fully formed plan, by next January, filling it out and making a perfect behavioral health system of care, but at least this is where they're looking to go in order to try and better respond quickly and effectively to what tends to underlie these cases. Yes?
I guess this is more a comment. I'm not a county attorney and mostly a defense attorney, and when I'm looking at the community-based efforts and what you were describing, it's somewhat similar to what has been implemented about the need to have a collaborative plan with schools before filing. And I don't know if that has changed how the county attorneys work, but I haven't really seen much of a change in my practice in terms of those cases still being filed. Now to get a copy of the collaborative plan, for instance, a case where there is no truancies or tardies, half of them are illnesses and half of them are medical, and it's marked that there is no health issues or any other services that are needed in that regard, which is somewhat absurd. So I've seen those collaborative plans becoming more, okay, we're going to have the meeting and fill out these because we need the paper, but it's really not making a change.
So I have another comment that some of the language is reminiscent of the changes to the law regarding truancies particularly, and that the law requires a cooperative plan responding to student truancy before cases can be filed, and that the efforts have to be made in the schools before a case can come before the courts, and that she hasn't seen much change in terms of either the numbers or the type of cases that she's seeing. Is that?
Yes, I mean, I haven't seen the collaborative plans really work very well, I guess it's more the point I'm trying to make. And sometimes the way they are filled out is it just doesn't make any sense. If you look at the documentation, it's clear there are certain issues, and the paper just says, no, there is no issues.
Yeah, and that specifically the collaborative plan and the way it's filled out doesn't seem to match with the reality of what's going on in the case or be particularly useful. All I can say is we've got these laws on the books. If you have a little extra time to challenge things on appeal, go for it. I feel this. I spoke recently to a public defender's office about a similar presentation, and I felt like half of my responses were, well, you know, fight it in court and then appeal it, which isn't fair to say to a room full of busy practitioners. But you know, we have these laws on the books, and if you feel in an individual case like what the law requires is not being met for your client, that's really the only thing I can say. Although that was more of a comment, not a question, so I guess I didn't have to respond at all. Are there any other thoughts or questions on LB 482? Man, I've talked almost the whole time just about this one, and we've got Sarah still for child welfare. I'm not taking any more questions, guys. Come speak to me after. All right, so I'm just going to blast through these other ones because that one was the bulkiest, as I said. LB 265 addresses the Foster Care Review Office and creates a couple data collection centers. On the chart that we gave you that has all of the child welfare and juvenile justice bills, you can see listed the particular statutory provisions that are changing with this bill, but as functionally for practitioners, you should know that the Foster Care Review Office is now extended to juvenile justice probation cases where the child is placed out of the home. And it's also extended to quote-unquote trial home visits, so where a child is coming home from an out-of-home placement, but they're remaining either a state ward or under probation supervision for 6 months, for up to 6 months. And also Foster Care Review Board reports shall be admitted. Office of the Inspector General, LB 347, now has full oversight of juvenile justice cases as well as child welfare cases. So cases where there is a serious injury or death, OIG already oversaw those and investigated for probation cases. Now they're a complaints body, so if there is some complaint about probation or the courts or the process as the agent, they're a wing of the ombudsman and can investigate complaints. I'll skip LB 500 because as lawyers, I don't know if it'll affect us much in the next year or so until these teams get off the ground. And finally, LB 605 has a whole slew of provisions regarding adult criminal charges and sentences, but specifically there's a piece where Medicaid is suspended rather than terminated for incarcerated persons, and this could include children who are placed in secure detention. So their Medicaid, rather than being terminated when they're detained, should just be suspended, and the Department of Health and Human Services Medicaid Division and probation or corrections have to work out a communication plan so that your kids shouldn't be sitting in detention centers waiting for Medicaid to get sorted out before they can go to a placement. And I'm finally done. Here is Sarah to talk to you about child welfare.
Okay, let's see. Hello everyone, I'm Sarah Helvey, and I'm a staff training director of the Child Welfare Program at Nebraska Appleseed. I will just skip this slide because Robbie gave a great introduction to Nebraska Appleseed. I work with Robbie. So what my task today is to talk about a few child welfare bills that passed this session. Two of the biggest ones I'm not going to talk about because one of them was the ICWA bill that you just heard about from Robbie. Another one of them is LB 15 regarding the GAL standards that Judge Paine is going to talk about next. But I have three others for you. I think Juliet made a reference to, in your materials, there's a chart that we created of pretty much all of the juvenile justice and child welfare bills that were introduced this session that our organizations were monitoring and the kind of the final outcome on those bills. So again, I'm just going to be talking about three child welfare bills that we think are probably most important to you as practitioners, but if you are looking at that chart and have any questions about other bills that passed that are maybe more technical or they were introduced and didn't proceed, feel free to ask those questions as well, either during the presentation or I think Juliet and I would be happy to talk afterwards or later about those as well. So the first bill that I'm going to talk about is LB 243. And that was introduced by Senator Kate Bowles. It includes kind of two primary things. First, it created a pilot project to provide family finding services in at least 2 service areas across the state and directs the department to contract with providers to provide those family finding services. And then it also directs the department to contract with academic institutions to conduct an independent evaluation of those family finding pilots. So hopefully we'll be seeing more family finding in cases across the state, and that's a great thing. And then an amendment, what I'm going to talk about a little bit more is an amendment to LB 243 incorporated a separate bill, which is LB 441. That was also introduced by Senator Kay Bowles. I call that a bridge independence cleanup bill, but it's the second bridge independence cleanup bill. As a reminder, I'll kind of skip. I was going to talk a little bit about Bridge Independence Program, but I'll assume for the most part that you all are familiar with that program. But in general, it extends services and support, foster care services and support to young people who age out of foster care to age 21. It includes a stipend of $760 per month, Medicaid coverage, case management support, including monthly meetings with a caseworker. There are some eligibility requirements, and also 6-month reviews by the Foster Care Review Office and annual permanency hearings by the juvenile court. Young people in the program can request a court-appointed attorney that's client-directed. We have about 133 young people currently in the program across the state. As I said, this is the second cleanup bill. The program was passed originally by LB 216. Introduced by Senator Amanda McGill. There was a cleanup in 2014, and then this is, I keep saying the last cleanup bill, but that said, it's probably not, because there are efforts, which is a good thing, I think. There are efforts already underway, and Juliet's helping to lead that up, to look at how we can expand the Bridge Independence Program to include young people with juvenile justice experience. So there's a stakeholder group that's going to be coming together on that, and so there may be a bill in the future to look at ways to expand and improve the program further. So I want to just mention, and this gets kind of technical, but I'll try to walk through it quickly, the changes to the Bridge Independence Program in LB 243. The first is that there are 2 changes to eligibility. It expands eligibility for the Bridge Independence Program not only to youth young people who are adjudicated 3A, but also, quote, the equivalent under tribal law. And that was just a kind of inadvertent oversight. That population was intended to be included, but we realized under tribal code it's not 3A. And so that language was added. I will say that there are conversations happening about what that looks like. How do the tribal courts and the state courts interact? How does the tribal social services and the state social services interact? So those conversations are happening, but those young people are now eligible under the statute. It also extends eligibility for young adults who are guardianship at age 16 or older. This also gets kind of technical, but under the old program, we had kind of a confusing extended guardianship assistance program. So young people who were guardianship at age 16 or older were eligible for their guardian to receive a continued monthly stipend to age 21. There were but it was a bifurcated program. Young people that were in a guardianship with a relative at age 16 or older were eligible for, like, as an entitlement, that continued subsidy, and Medicaid. Young people who had a state guardianship agreement were only eligible within the extent possible within existing funds because of some legislative changes. So it was really confusing, bifurcated program. And also the kind of biggest concern was from young people that they weren't able to receive that stipend directly, and they weren't able to access some of the other services and support in the Bridge to Independence Program. And we saw that. We heard that a lot from young people. And then we saw that there were, at the time of the bill, there were no young people that were taking advantage of that program. So under this new law, the new bill, young people who were guardianship to age 16 or older have the option either to do that extended guardianship or to go into the Bridge to Independence Program, receive that stipend directly. And so there's some requirements that HDS provide notice to the young person about that option, what it kind of means, what the different programs are. I would really encourage you as GAL or attorney for a child that is guardianship, has a late guardianship, to explain those options to them as well. And then second, LB 243 clarified that young adults who meet eligibility for the Bridge to Independence Program or also that extended guardianship or adoption assistance are eligible for Medicaid to 21 by virtue of their participation in that program. There were a few gaps there that cleans up. And then LB 243 established really just the term independence hearing, which is kind of new name for that already existing last court hearing before young people age out of foster care. The law now directs the juvenile court to advise the child about the Bridge to Independence program, including their right to request an attorney, their right to request a permanency hearing, the rights they'd be getting, and the rights to be getting up if they choose not to participate in the program. This really came up as to address concern of judges and others that there was some differing practice, I guess, when the program started. Some judges were wanting to hold a hearing right away, I think in part because they wanted to do some of that advisement of rights and appoint an attorney, and so they can still do that, but this gives them an option to use that already existing last court hearing to do some of that advisement of rights, and I think it more rightly puts some of that advisement responsibility on the court rather than HHS, who's always sometimes not in the right position to be doing that. And then there are a few timeline changes under LB 243. It requires the department to begin providing services and support within 15 days after the agreement signed. It was previously 45. And then there's also some technical changes to try to make the process as seamless as possible for young people who go directly into the Bridge to Independence program after they age out. And not, so it specifies that the petition is to be filed with the juvenile court upon a child's 19th birthday or within 10 days thereafter, and that there's no interruption in Medicaid coverage or that foster care maintenance payment for young people to go directly into the program from aging out. There was some blips there too, where before it said the department had to file the petition and the agreement at that last court hearing, but HHS was like, well, they're not 19 yet, so we can't have them contract, and they're not actually eligible till they're 19, so we can't do that yet. So this corrects that. It helps to be seamless for the young people while also making sure that HHS can actually meet that requirement. And then there were lots of questions about confidentiality that this came up in the Supreme Court Commission on Children in the Courts meeting and other meetings. Are the B2I hearings confidential? And so this legislation specifies that all pleadings, filings, documents, and reports in B2I cases and the proceedings are confidential unless the young adult provides a written waiver or a verbal waiver in court, and then also says that that waiver can be made in order to permit the proceedings to be held outside the courtroom. You remember there's some language in the B2I legislation that hearings can be held in more informal places, and that confidentiality can waive for that purpose. And then also some language that doesn't prevent the juvenile court from issuing an order identifying individuals who can receive otherwise confidential information for legitimate official purposes under that 43-3001 statute. So real quick, I think that just the practical takeaways, as I said, are guardianship youth are now eligible, tribal youth are also now eligible, and also people in Bridge to Independence should be covered by Medicaid. If you are working with or representing a young person who is not, please let us know, and we'd be happy to provide some technical assistance on that. Let me pause really quickly and see if there are any questions on those changes. I'm feeling left out. Robbie and Juliet got so many questions, but I know that's really technical. So a couple more. LB 292 was introduced by Senator Colby Koash, and this addressed some concerns about, about the central registry, particularly as it relates to minors. And I think the impetus for this bill was some data actually that I believe Senator Koash had received from the department showing that intentionally and unintentionally perhaps there were a number of young children on the central registry, and some very young children. And so LB 292 prohibits the placement of children under 12 on the central registry. And then for children aged 12 to 19, the law now requires a mandatory expungement hearing within 60 days of notice unless waived by the juvenile, their attorney, or their parent. They are to receive a notice that includes a waiver form and an explanation of the hearing process and an explanation of the implications of being entered on the central registry. And the copy of those notice materials are to be provided under statute to the minor child's attorney of record, parent, or guardian, and GAL. Do you have something to add? Okay. And then if the youth remains on the central registry after that initial expungement hearing, then if the expungement is denied essentially, then the law requires them to now have a second mandatory expungement hearing within 60 days of the youth's 19th birthday. The bill also prohibits the placement, the law now actually prohibits the placement of parents in no-fault cases on the central registry, which I know is a long-standing issue, and requires also immediate expungement if a court pending case is dismissed or a 3A case is converted to a no-fault. Yes.
I'll just add one thing on the on the bill. One of the things that Senator Koash mentioned in the impetus or justification was for having that second expungement hearing. There were people that put on the registry at age 5 or 6, and then by the time they turned 19, they realized they couldn't go be a Boy Scout leader, and they hadn't really ever received notice that they would have paid attention to when they were 6 or 7 years old. So that's kind of the reason why there is that second bite of the apple, the expungement hearing.
Yes, except for now that under 12 can't be on there, but and hopefully the attorneys and parents and everyone are helping, but that's a good secondary catch of that.
Maybe we should know this, but why would a 5-year-old be put on the registry? I mean, what was the underlying?
Okay, the question was why would a 5-year-old be put in the central registry?
Because there was no oversight for who goes on the registry, because there's no hearing unless you appeal your way off.
So by mistake, is that what you're saying? Or like they were a child in a 3A case? Or, I mean, what were the circumstances?
I don't know how much I can say specifically. Senator Koash has some of those details, but there were a lot of kids that were put on there by mistake. And there was no sort of review of who was on the list and who should be on the list, unless you appealed your way off it, because there's not a pre-deprivation hearing for the central registry.
The other question I had when you said that cases will be dismissed, taken off if they are dismissed. I mean, there's many cases that get dismissed without prejudice because the family is working voluntarily with HHS, and they get put on the central registry even if there isn't a court case. So I guess I'm trying to understand what that would mean. Like if there is a court filing, I can understand if the court says I'm not going to adjudicate after a trial, there for sure will be taken off. But if it's just a dismissal without prejudice to work with HHS, is that going to apply?
Do you know the answer to that? I would say I think that I mean, one of my practical take, the question was if a case is dismissed without prejudice, right? Then is there going to be oversight to make sure that that case is not put on the central registry? Is that a fair?
Well, no, maybe I misunderstood what you said. I thought you said that there will be an automatic taking off the central registry if your case is dismissed. But there is many different reasons and different ways that a case gets dismissed. So is there any qualification to that?
There's no qualification. So the question, sorry, let me say it better, is that there are many ways that a case is dismissed, and is there any qualification in this statute about that impacting the case being removed from
Are we talking about the county attorney dismissing the case, or are we talking about the court not adjudicating?
I think the language is if a court pending case is dismissed or a 3A is converted to a no fault. And so the obligation is and the statute is on the department to do that, and there's no qualification about the way that it's dismissed, the moment it's dismissed, how it's dismissed. So I'm sure it's not going to be perfect, and one of my takeaways for attorneys is that there needs to be oversight. And I think you're going to need to ask that question. You're going to need to...
You need a court case to have your name on the central registry. They put the names all the time without even having a court case.
That's right. So there's a category of being on the central registry called agency substantiated. And that is where you can be put on the central registry solely by the discretion of the department. Is that what you're referring to?
They remain there because it's agency substantiated even though the case was dismissed.
So I think I think that this eliminates the agency substantiated for children. Is that correct?
For court-involved children.
For court-involved children. So it could still be an issue for others, but this bill, and I agree that that's a problem, that category has been one that we've been concerned about for many years because of the discretion there, but this bill is really aimed at addressing the issue for minors. So I think there's more reform that could be done there. And then I think that there's also, I just want to mention there's also required that the department provide annual reports to the governor and the legislature of the number of cases entered on the central registry in which the subject is a minor, their ages, and the number of cases that are classified, and how those cases are classified.
Good question.
Yeah.
Is there, and it may not be addressed in 292, but is there a way that somebody can ask for a hearing even after the 60 days past their 19th birthday? And the reason I say that is you might be put on here when you're 12. If it's like the families in my jurisdiction, they've moved 15 times by the time the kid's 19. How am I going to find them?
Yeah, so the question is there a way beyond the points that are noted in this bill to have an expungement? And that is already in the existing statute, that you can request an expungement at any time. And so this is just trying to provide that extra protection for children, that there are mandatory, those expungement hearings are mandatory, but people who are on the central registry can request those at any time. Yes. Great.
I'm not sure if I missed this, if you already said it, but have these bills already been passed? Where are they at?
Yeah, so there was a question about the bills that I'm talking about and whether they've been passed. Yes. The 3 bills that I'm talking about and the ones that Juliet spoke about as well are all bills that passed the legislature this spring, this year.
The ones I spoke about become effective August 30th.
Yeah, and the ones that Juliet talked about became effective July 30th, August 30th. And then I should know about these. Do you know, Robbie, off the top of your head on these?
I think any of them had it.
There were not 8. I don't think there were. There were for portions of the LB 243 an emergency clause, but so I believe they're all in effect now. Would be the bottom line for practitioners. Okay, let's see here. I can do this really quickly. So LB 296 is a bill that adds a requirement from a new federal law called the Strengthening Families Act that was passed by Congress in October of 2014. And so it adds a requirement. So there's, when a child is removed from the home, the Fostering Connections Act a few years ago required the department to provide notice to relatives within 30 days of the removal from the home. And this adds the requirement that that notice also be provided to parents who have legal custody of a sibling of a child. So that would include examples like step-parents, children with a different dad, adopted parents of a sibling, etc. And then the federal law in Nebraska now define the term sibling to include an individual who would have been considered a sibling under Nebraska law, but for a termination of parental rights or other disruptions such as the death of a parent. So I wanted just to mention real quickly, the Strengthening Families Act, that federal law, has a lot of really great provisions about normalcy for children in foster care, about trafficking for children in foster care, about children who run away from foster care. And so there is a group of stakeholders that are making recommendations to the state about how to implement that best, and we'd love to have some GALs involved in that. So if you're interested, please let me know. And then just also a plug, I'm doing a presentation that really gets into the nitty-gritty of the Strengthening Families Act through the Eyes of Child regional conferences, because there is a lot there, and that law is going into effect. Most of the key provisions are going into effect at the end of September. So there's a lot there. If you have any questions in the meantime, I have a lot of resources on that I'd be happy to talk with you about as well. So we're over time. I stole a little bit from Judge Paine, so we'll pass it over to her. If you have any questions, you can reach out to either me or Juliet afterwards or separately. Thanks so much.
Hi, my name is Ann Paine. I'm a county judge from McCook, the western part of the state. I serve in several small courts, McCook, Beaver City, Trenton, Hayes County, and then I fell in other courts out there. My background is I was an attorney for about 19 years in a small town. Did about a third of my practice was juvenile law, did a lot of guardian ad litem work in 3A and 3B types of cases. I became a judge in 2007, do a lot of juvenile work in county court system. I've served on the guardian ad litem subcommittee for the Supreme Court Commission on Children in the Courts for many years. I forgot when I first went on, I think it was 2006, but I've served on that commission subcommittee for quite a few years on and off, and was the chairperson for that subcommittee for quite a few years. The topic I'm going to be talking about today is LB 15. I'm going to talk a little bit about the history of the guidelines and how we got to what are now the rules. I apologize, I don't have PowerPoint. I really apologize to the people that are on the webinar. I didn't know that it was going to be on the webinar, but I asked them to give you a hard copy because I wanted you to have a hard copy of the rules to take with you, and the new form, the guardian ad litem recommended form, so you would have that with you and could take with you. But if the people watching the webinar, hopefully you can pull it up on the net so that you can be looking at it. In 2007, the Supreme Court adopted guidelines for guardian ad litems for juveniles in juvenile court proceedings, is what they were called. They were intended as guidelines or best practices only. They were not intended to be Supreme Court rules. So if you're familiar with Pirates of the Caribbean, they were not rules, they were just more like guidelines, I guess. So violation of the guidelines did not require any disciplinary action, and many times over the years they were recommended to become rules. I know our subcommittee recommended many times that they become rules. I think the Supreme Court Commission recommended many times that they become rules, never came to fruition. I just wanted to read a little excerpt. I think it describes it better than I can, from Christine Constantego's Juvenile Court Law and Practice book. Talks just briefly about how the guidelines were developed. I think it's important to note that because the guidelines basically became what we now have as the rules. It says the guidelines for guardian ad litems for juveniles in juvenile court proceedings were not adopted in a vacuum. They were born of the labors of the Guardian ad litem Subcommittee of the Nebraska Supreme Court Commission on Children in the Courts. The subcommittee was formed to evaluate and make recommendations regarding the Guardian ad litem system in Nebraska juvenile court proceedings. The members of the subcommittee examined and considered different models of Guardian ad litem used in other states, and also wrestled with many thorny issues over the course of 2 years of the subcommittee's deliberations. The resulting work product represented a consensus draft of the subcommittee with minority views noted on certain aspects. The document was originally styled as proposed rules of practice for guardians ad litem. They were approved by the Nebraska Supreme Court Commission on Children in the Courts and then forwarded to the Nebraska Supreme Court for its consideration. The Nebraska Supreme Court adopted them with minor modifications in the form of guidelines illustrating best practice standards for guardians ad litems in juvenile court proceedings. So that's where the guidelines came from. And LB 15 was introduced by Senator Christ and carried an emergency clause and was approved by the governor on April 29, 2015. LB 15 amended Nebraska Statute Section 43-272 to state that the Supreme Court shall provide court rule standards for guardian ad litems in all juvenile court proceedings by July 1st, 2015. So that's what was created by LB 15. In response to that, on June 24th, 2015, the Supreme Court adopted rule amendments to the Nebraska Court Rule Section 6-1468 and Appendix 12 and Section 6-1705 and Appendix 1, and approved the deletion of the existing guidelines for guardians ad litem for juveniles in juvenile court proceedings. So they adopted the new rules, deleted the guidelines. These new rules are entitled Practice Standards for Guardians ad litem for juveniles and juvenile court proceedings in county courts, that's section 6/1468, and practice standards for guardians ad litem for juveniles in separate juvenile court proceedings. Of course, that would be Douglas and Sarpy and Lancaster County, respectively. Now I want to talk about what those standards are. Sections 6/1468 and 6/1705 are basically identical. They're for the county courts and the separate juvenile courts. They're divided into different sections. The first section talks about the purpose. Purpose, of course, is to provide for the best interests of kids and the best possible legal representation of juveniles in these types of proceedings. The next section is about appointment. The appointment of guardians ad litem in juvenile court proceedings has to be a lawyer licensed to practice in the state of Nebraska. The duties shouldn't be delegated. It talks about there has been concerns about it's in I guess firms that have larger caseloads for guardians ad litem, that some of the tasks have been delegated to legal assistants or staff to go out and do interviews or talk to the children, come back and report those to the guardian ad litem. Guardian ad litem write a report based on interviews done by someone else. To every extent possible, these rules say that work should be done by the guardian ad litem themselves, if at all possible. So they discourage delegating those sorts of duties. Also, the guardian ad litem must complete the guardian ad litem training. That guardian ad litem training also was born out of that guardian ad litem subcommittee. Lots and lots of work and thought and discussion, heated discussion, has produced that training. It's supposed to be very nuts and bolts, real boots on the ground kinds of training rather than theoretical kinds of things. This is how you write a report. These are the people that you interview. This is the kind of stuff that you do. The whole purpose of it is to designed to give you the best possible representation to kids and to help guardian ad litems understand exactly what their job is and how to do it the best possible way to help you and assist you with that. The next section of the rules talks about the role of the guardian ad litem. Nebraska has embraced the dual role. That has been attacked at different times. Different people have thought that guardian ad litem should just be an attorney for a child. We shouldn't have best interests, and that it's hard to do both those tasks. Nebraska has continued to defend that dual role, and so a guardian ad litem in the state of Nebraska looks after the legal interests like a lawyer and the best interests like a parent, and advocates for both of those. If the roles conflict, there's a specific section in the rules that talk about the procedure to ask for separate counsel. I was going to talk a little bit about that. There's specific factors that you look at: the juvenile's age, the juvenile's capacity, their level of maturity, the nature of the inconsistency between what the juvenile's expressed preference is and the guardian ad litem's thought of what is in their best interest. And then it goes into great detail about how the guardian ad litem makes that determination of whether that is a situation where they need to ask for separate counsel. And in those circumstances, they weigh all those things and then present that to the court, make in the form of a motion, and ask for separate counsel for that child. And then that guardian ad litem would continue on to look after the best interests of that child, but just ask for separate counsel for the child in those sorts of circumstances. The next section has to do with authority, the access to information for the guardian ad litem, their ability to gather information and talk to different people, the communication with the parties, and then it outlines a sample order for the court to provide in their court order. I know we use most of that language in our court orders, that when we appoint a guardian ad litem, that allows them to go into different places that maybe are resistant to giving you that information, to get that information that you're seeking without as many problems. The next section is on duties. This is probably the biggest one and the biggest concern probably that most folks have, and probably that the legislature had when requiring the Supreme Court to develop rules. The concern is to make sure that the guardian ad litem is doing all the things that they're supposed to be doing. Number one is consulting with the juvenile. It says that that's supposed to be in person unless impracticable. So talking to them on the phone, or talking to the foster parents and seeing how they're doing, all those things are good, but should be in person, meeting with that child if at all possible. So the first subheading under that is, at all times specified by the juvenile court, you're supposed to meet in person with the juvenile. Who can tell me what the juvenile court says that you have to, how often the guardian ad litem has to meet with the juvenile? At least every 6 months. When's the first time you have to meet with them?
Within 2 weeks.
Within 2 weeks after being appointed. And then every 6 months thereafter, at a bare minimum, right? That's what the juvenile code says. That's section 43272.01. And then second subsection is whenever the juvenile requests. So if they're asking you to come meet with them, you're supposed to go visit them. When you're notified of some sort of an emergency and prior to a hearing with substantive issues, and in every placement at least once. I wanted to talk a little bit about the importance of meeting them in a placement. I just want to give you 3 quick instances when I was a guardian ad litem where I thought it was absolutely, it was impressed upon me how important it was that I went and met with them at that placement. One of them, it was a toddler that was placed with his own parents, but they had just moved in with some friends. Caseworker hadn't even made it to their house yet, but they lived not too far from where I lived, so that about 15 minutes from where I lived. And so I hopped in my car and I drove there. They'd only lived there a few days, but I knocked on the door and I heard this scurrying in the background. I stood there for about 5 minutes before they finally answered the door, and they finally answered the door. There was 3 toddlers in a playpen that had that was ripped on the side. So immediately I was concerned that it was a choking hazard, worried one of them was going to choke themselves. While I was there, there was dog feces on the floor where the kids could be crawling around. There was exposed wiring that I could see, and all of this was things that I would have never known had I not been in that place. I immediately called the caseworker on my way home, filed a motion with the court the next day, got that kid out of there. But had I not gone there, would have never known those things. Another circumstance, I had a teenage boy that was placed in a foster home. I knew it was going to be a long-term placement, knew that the mother was probably never going to regain custody of that boy. So he was in a foster home of a foster mother that had been a foster mother for 13 years. On paper, she was a great foster mother. I'd never had a kid placed there, but he was just not doing well. He wasn't thriving, he wasn't doing well in school, and I just sensed that something was not right. I went there. He was not even there. He was at school, but I talked to the foster mother, and I visited with her on the phone, but it was just very cold. And I went downstairs and saw the room, and she had 6 foster kids in there. Little twin beds were lined up like military style, and it was just a sense of just coldness and no warmth at all. And I talked to him the next day, sat down with him and said, what do you think? You want to look at a different foster home? And he was absolutely in agreement with that. I got him in a different foster home. They later on got guardianship of him. He absolutely flourished, was involved in all sorts of school activities, and still graduated, and still comes back and considers them his family, long-term family. So again, had I not been there, she looked like a great foster parent on paper. She had all the experience, but just absolutely not a good fit for that kid. And then the last one I'll share with you is I had a kid that was in a sex offender treatment center clear across the state, and he'd been there about 6 months, was not moving up levels, or if he would go right back down a couple weeks later, just not doing well at all. And I knew it was going to be very expensive for me to go all the way across state. I'd been talking to counselors there, I'd been talking to him there, but just thought this kid is not doing well for some reason, and I asked the court for permission. I figured out exactly what it would cost to go there and see him in terms of travel expenses, my time, the meals, those sorts of things, and made a motion before the court, and judge approved it. And I drove up there to see him and just got a bad feeling. Not necessarily that the facility was bad, but he was just not meshing there well with the counselor. I met with him and the counselor together. It was not a good rapport, that sort of thing. So then I immediately started looking for a different placement for him. He got accepted finally at another group home. Not saying he did fabulously, but he did much better in the other treatment facility. So in all those circumstances, it just impressed upon me the importance of, even when it's difficult, even when it's a long ways away, even when they're placed with their own parents, it's just important to see those kids in the placement. I don't think there's any substitute for that whenever you possibly can. So those are just my quick stories about how important it is to see a child in a placement. And that kind of works into the next one. If it's a long distance, you can ask the court in advance to approve those expenses. I just talked about that, but you can ask the court, and I've had attorneys do that with me, file a motion, and they just kind of outline what they anticipate their expenses will be in advance, and I always approve that unless there's some reason not to, but every single time I've approved that ahead of time because I think it's important for them to see. Never had a guardian litem ask me unless they thought it was really important for them to go a distance and see that child. Then lastly, the rules define exceptional circumstances, which is a long geographic distance, and then it gives you different ways that you can visit that child if you absolutely are too far away to visit them in person. Of course, talks about telephone. I know that a lot of guardian litems will Skype with a child and those sorts of things, and so there are other ways you can visit, but that's one of the things you can do. The other thing that I was going to say, that one of the things that you can do also, if it's a facility a ways away, sometimes I have visited a facility even if I don't have a kid there when I was doing guardian litem work, and now as a judge, if I'm in a town, and I live clear on the western part of the state, so if I'm in the eastern part of the state, sometimes I'll go visit a facility just because I want to familiarize myself with it and understand their program and see that facility and become comfortable with knowing what that facility is like. Okay, so that's the duties, or the consulting with the juvenile, and then the other duties are the inquiry, who you talk to, and I would like to get your ideas on who do you think it's important to talk to when you're getting ready to go to court and provide that information to the judge. Who do you think it's important to talk to?
Schools, the child's therapist, there is one, foster parents.
Yeah.
I guess that was a given, sorry. Caseworker.
What's that? The parents. Oh, and I'm not repeating these. They said the school, therapist, the parents, HHS worker, CASA worker if you have one. Sorry.
Child.
The child. Yes, absolutely. Doctors. Depending on the age of the child, could be friends, could be daycare workers. That's a good one. neighbors. Depends on the circumstances, absolutely. And then the rules talk about the reports that you review, of course, the case plan and court report, CASA report if there's any. So it talks about all the reports that you need to review. The guardian ad litem then has to file a report with the court at all disposition hearings and all review hearings. The guardian ad litem is supposed to file a report with the court. There's now a sample form that's provided at Appendix 1 and Appendix 12, which we'll discuss. We'll go through that report here in a few minutes. Guardian ad litem is to participate in all court proceedings, and unless excused by the court. I have had times where we were just going to have an admission or denial by the parents, and the guardian ad litem couldn't be there or just wanted to participate by phone, that I've excused the guardian ad litem from being there. But generally speaking, the guardian ad litem has to be at all court hearings. Testified to the extent allowed by the rules of professional conduct, and provide quality representation. And it specifically talks about no excessive caseloads. I can tell you that our guardian ad litem subcommittee has made recommendations regarding limiting caseloads. That's never been approved. It's very touchy subject. It's difficult for that to happen, but it's something that's basically an ethics kind of a thing that attorneys need to make sure that they're not taking on excessive caseloads, that they're not taking on more work that they can handle, particularly when representing children, that they are providing quality representation for children, and these rules require that they not have more than they can handle with respect to representing children as guardians ad litem. Then the next section talks about termination. Guardians ad litem are supposed to continue representation until the court releases them or terminates jurisdiction. They can file a motion to withdraw if they have a conflict of interest or something happens where they need to withdraw. They can also be removed by the court. I did visit with a couple of people on the guardian ad litem subcommittee and said, I want to know, has there been any discussion anywhere that you're aware of regarding if there's going to be any sort of disciplinary action with regard to these rules, or any action that the court is going to be required to take if they see something where the rules are not being followed. Is there any discussion going on out there? Because I figured that was a question that I was going to be asked. And as far as I know, and as far as the people that I visited with, I don't know of any right now. I don't know if there's any coming. I don't know if any of you know anything about any of that. But they're so new that we don't know what the ramifications are going to be at this point. But they are rules. They're going to probably be cited as authority. And so generally speaking, my guess would be that if you were not following, the guardian ad litem was not following the rules, that in most circumstances I would think the judge would basically pull them in and say, hey, in a personal discussion, say, hey, wait a minute, this needs to happen. Let me show you this has to be followed. And then also probably could remove them from the case, would probably be the action that I would take in that order. The next section is on compensation for those not covered by multi-case contracts. The Supreme Court, it says the Supreme Court may establish a uniform minimum hourly rate of compensation for guardian ad litems. That has not ever been done that I'm aware of. I don't know if it ever will be done, but they have that right to do that. In our jurisdiction anyway, it's set by the court, and mostly district-wide. Usually the whole district sets a rate of compensation. All hours should be reimbursed, including travel time. I know that there's been a push toward having all guardian ad litems compensated by the hour rather than by contract, but I don't see that changing anytime soon either. Okay, questions before we move on to the sample guardian ad litem forms? Yes.
In your view, at least in your jurisdiction, it probably would vary from attorney to attorney. What would you view as a reasonable range of cases for a caseload?
Okay, the question is what a reasonable range of cases for a caseload would be. That is so difficult to say because in our area, at least, we don't have anybody that does just strictly guardian ad litem work. They do so many different types of cases. And I would say when I was doing them, I was doing, like I said, probably about a third of my practice was guardian ad litem work. If I got up to the neighborhood of like 15 kids, then I felt like I was getting beyond more than what I should have because I wasn't giving it the attention it deserved. But that's because I was doing divorces and criminal work and probate and lots of other things at the same time. But when we were discussing in the guardian ad litem subcommittee, we were talking in the neighborhood of 40 to 60 cases maybe, but 40 to 60 kids. But I don't know that there's any hard or fast number or that there was any real basis for that. That was just a feeling that, but I think it depends on how many hours the attorney's putting in and how many other types of cases they have. So I don't know that there is a good answer for that. Yes?
Maybe I misunderstood, but or maybe you're talking statewide, but I thought that, at least in Douglas County, that all the multi-case contracts were ended as of June 30th.
That may have been for Douglas County. The question is whether all the multi-case contracts were ended in Douglas County, and that very well could be. I think I actually did hear that ended in Douglas County.
I was part of the Monahan crew, so they ended up June 30th.
All right, we're getting that confirmed. As of June 30th, the multi-case contracts were done.
You don't see multi-case contracts as disappearing across the board?
I don't see anybody forcing that happening.
Okay.
That I don't think the Supreme Court would take that stance of making the counties do that. But I could be completely wrong. But I think that's probably a decision Douglas County made.
I think I can speak a little bit to that, at least on the LB 15, that in the creation of it, I know that the idea of eliminating contract-based systems was considered and rejected because people from Lancaster were coming forward and saying, we have a really satisfying contract with our legal aid, and that's really working for us. Please don't eliminate it statewide based on what's happening in Douglas.
Okay, and the comment was that Lancaster County advocated strongly for keeping the multi-case contracts in Lancaster County.
Well, maybe you can say more about it. I don't know what was behind the decision as far as in Douglas.
I don't know the answer to why Douglas County got rid of their contracts, but okay. I did want to take a few minutes and look at the sample guardian ad litem form. This was primarily developed again by the guardian ad litem subcommittee, although there were some changes to it. The form, I think you all have a copy of it, is pretty self-explanatory, but it talks about the date of the report, the date of the hearing, the type of a hearing, whether it's an adjudication, a disposition. I probably wouldn't be providing a report for the adjudication, but probably a disposition, review, permanency hearing, that type of a hearing. Who the parents are. Then it has different slots for children. Some cases or some jurisdictions have cases where there's just one child per case. Some have multiple children per case, so there's room to make entries for several different children. Then the next section, of course, the contact with children since the last hearing is probably the most important. The judge is going to want to know when you saw the child, where, what type of contact it was. If there was no contact made, please explain why. That's going to be very critical. If you haven't made any contact, that judge is going to want to know why you haven't seen that child. Then express preferences, if any, of the children, if any. It's going to be important if they have something that they really want the court to know. Are most of you guys using the youth information forms here? As a judge, I find those very helpful. Even with little kids, I learn a lot about kids, and it also gives you a way to talk to kids in court. Yeah, the youth questionnaire forms.
Have you seen the ones for the real?
Yes, that's what I'm talking about. Even those help me a great deal. They give you something to talk to the kids about, and you get a little insight about who the most important people are in their lives and that sort of thing. I think it's very helpful. But questionnaire forms. If you don't have them as guardian ad litems, I don't know who just. But I don't know who's distributing them to your kids or having your kids fill them out. Mostly it's our CASAs that are doing it in our area. But if there's guardian ad litems in the room, if you can get them to your kids and have them fill them out, as a judge, I find those incredibly helpful. I just get a lot of insight into a child. It's my chance to find out what they're thinking. Just in sneaky little ways, because they will talk about what the most important things are to them or what they really like, and it just gives you some insight into those kids and what's important to them and how they're feeling. So, persons and other resources contacted since the last hearing, the people that they visited with, and then the documents reviewed since the last hearing. And then the next section that's really important is the guardian ad litem narrative, and that if it's not long enough, there was a big worry that wasn't going to be a long enough space. You aren't limited to that space. You can add space to it, but to put in all the information that you want the court to know, what you really think is going on in a case, what your concerns are, what you think is going well, how you think the case is moving. And then the next page is recommendations. You think that the children could return home or not return home. There would be a risk of harm if they remained in the home. Recommend removal. The possible barriers to permanency. And then the next section says, I've identified the following active efforts. And I actually emailed Christine Constantakos yesterday, who was on the guardian ad litem subcommittee with me, and I said, how did that turn into active efforts rather than reasonable efforts? Did I miss that discussion? And I said, was it because of ICWA that they changed that to active efforts? And she said to me, I don't think that was our language. I think that language got added, and she also assumed it was because of ICWA, and also the discussion that we had this morning that maybe we're all moving toward that goal of active efforts rather than reasonable efforts. But we also had the discussion that, whether it's the guardian ad litems should be making those findings about reasonable efforts or active efforts, or whether that's the prerogative of the court. But that's just, I guess, the guardian ad litem's view as to whether they think those efforts are being made or not being made at that point, and whether the judge makes that determination is up to the judge. And then whether they agree or don't agree with the recommendations by the Department of Health and Human Services, or whether they think additional things should be in the court order, and then or whether they just think that the case plan should not be adopted at all. So that's the guardian ad litem report. Any questions or concerns about the report? Yes.
On the barriers to permanency, is that looking more for what parents are doing or not doing, or is that more, I talked to the foster parents and they're not willing to be an adoptive home?
I think the question is what the section on barriers to permanency. I think whatever the permanency objective is, as a judge anyway, my feeling is whatever the permanency objective is, if the permanency objective is adoption, then the barriers to permanency at that point would be that whatever home they're in is not willing to take them on as an adoptive parent. If the permanency objective is reunification, then it's that the parents haven't followed through and done their treatment, substance abuse treatment, or that they aren't exercising their visits or those sorts of things. Whatever that permanency objective is, why aren't we getting there, I guess, would be what my thought would be. Other questions about the form? Yeah.
Sorry, it's not a question about the form.
Oh, that's fine.
So, Judge, I think you'd mentioned have the child's expressed interests piece and the forms that children can fill out, and I think you said that gives you a hook of something to talk to them about. So I know it's not necessarily regular practice in all jurisdictions for children to appear in court, and I guess I think there's language encouraging that appearance in the standards now. So what's your take and what's your experience on that?
The question is about children appearing in court. I have a policy that the general rule is that kids appear in my court, even little kids, which is sometimes very disruptive in court and not always great. But we have CASA workers that are usually pretty good about if it's getting really bad, taking them out in the hallway or something. Our CASA has also just developed a little bag of things for them to, like crayons and toys and things like that to keep them entertained in court. But I see things that how they interact with parents and foster parents and things that you just don't see otherwise if the kids aren't in court. And all the information that I receive is that it's so important for kids to come and see what's happening in court, and that they feel like they're being left out or kept in the dark if they're not there. There are certain times where there's certain types of hearings that they probably should not be at. Generally speaking, I leave it to a great extent up to the guardian litem whether they should be there for that particular type of a hearing. And if the guardian litem thinks they shouldn't be there, then they get a hold of the caseworker ahead of time, and I go with their preference a great deal. But when in doubt, I like to have them there. So usually the kids are there, particularly the older kids. But I would say probably 80% of the time kids are in court when I'm there. And a lot of times also if they have some school function or something, or they're going to miss school, then maybe no. But like I said, probably 80% of the time they're in court. And they like to be there. And most of the time I can get a dialogue going with them, and they want to talk and they want to tell me what's happening, and they're all excited to tell me what's happening. And like I said, those youth forms help me a lot, because even the little ones, if they've written that they like baseball or whatever, then I can start talking to them, and then they'll get a dialogue going. So, yes, you had a question.
Oh, I think I was just going to ask, and I can clarify. I mean, my concern is there's a lot of times when animal approaches or hearings as to have parents doing they have issues with police and things like that, traumatizing that child for that. But I think you need to kind of answer this first regarding what that's anticipated.
Yes, there's absolutely times that kids should not be in court. There are.
you.